Ms. Kagan began her efforts to reverse the policy when she joined 53 of her academic colleagues in filing a brief to challenge the Solomon Amendment. And this was a case had been filed in another circuit, not Harvard's, but another circuit. If their efforts in this legal attack were successful, they would again obstruct the military's access on campus, and they could do so without losing federal funds. That's what she wanted, no doubt about that. So initially, the Third Circuit, who heard Third Circuit Court of Appeals, not her circuit, heard the case, and they issued a decision 2-1 that ordered the district court in New Jersey to issue a preliminary injunction suspending enforcement of the Solomon Amendment in that district in New Jersey. The injunction was to take effect after a certain time period, I believe 50 days. But that injunction was never issued, even in that one district of New Jersey, because the Supreme Court of the United States undertook to hear the case, and the Court of Appeals, respecting the Supreme Court's view, eliminated their order staying the enforcement of the Solomon Amendment. But I would note, even if the Third Circuit's ruling had not been stayed, it would have only applied to the Third Circuit, not the Harvard. Remember, the Solomon Amendment was a duly enacted law passed by the United States Congress. Fully understanding all of this, as a trained, educated dean that she was, Dean Kagan still used this ruling as a pretext to deny the Solomon Amendment's enforceability at Harvard campus, again kicking the military out of the campus recruiting office. It did not apply. It was never made applicable, and certainly not made applicable to the Harvard campus. But yet she used that as a pretext to carry out her desires about the don't ask, don't tell policy. So we're told, well, don't worry about that, Jeff. They could still talk to veterans groups on campus. They weren't barred from campus. They just couldn't use our center for recruiting, but they could still talk to people on campus, and it's not so important. If it's not so important, why did Dean Kagan go to such lengths to have the law overturned, even risking Harvard's financial support? It was important. Barred from institutional access, the military now had to work through a student group, the Harvard Law School Veterans Association. The Veterans Association, however, didn't feel like this was fair to them. They had courses to do and schoolwork to do. They wrote to their classmates after Dean Kagan's decision and explained that they were unable to fill the role of the military recruiters that she had excluded. This is what they said, quote, "Given our tiny membership, meager budget, and lack of any office space, we possess neither the time nor resources to routinely schedule campus rooms or advertise for outside organizations, as is in the norm for most recruiting events," close quote. But the dean still didn't relent. Only when the military again threatened to cut off money to Harvard did she give in. So this was the second time that they had to make this threat, which this statute says that the Secretary of Defense shall notify them they'll no longer get federal funds if they don't allow recruiters on campus. So Ms. Kagan reversed Harvard's existing policy. In order to obstruct the access of the military recruiters, she disregarded a congressional statute. Eventually, her view was rejected by the Supreme Court. Well, what happened when the Third Circuit Court got to the Supreme Court? Well, she filed a brief there with a group of other academics attacking the Solomon Amendment. And what happened? By an 8-0 vote, the United States Supreme Court rejected her brief. According to Dean Kagan, the actions that she took against the military were motivated by her opposition to don't ask, don't tell. But somehow her fierce opposition was not enough to prevent her, I would just note parenthetically, from serving as a loyal aide to the man who created the policy, President Clinton. No, instead, she directed her punishment to the military, who had nothing to do with it. The soldiers, the recruiters who wanted to come on Harvard campus had nothing to do with establishing this don't ask, don't tell policy. It was Congress's law, it's statutory, and the President Clinton endorsed it with his don't ask, don't tell enforcement strategy. It was the law of the land. It was not a policy dreamed up by some general somewhere. And she knew that. Ms. Kagan's conduct may have been applauded by some in the progressive circles of academia, but the American people, I think, will be uneasy about it. They will not be sympathetic to the actions she took against our brave men and women who defend the rights and freedom of Ms. Kagan, of Harvard, of professors, and all Americans. Dean Kagan has no judicial record to examine, and she has very little experience as a lawyer. And one of the most prominent features of her legal experience and her tenure at Harvard is scarred by her open mistreatment of the military and her disregard for very clear law. I wish it weren't so. I wish it weren't so. But it is. So this matter does raise questions of whether Dean Kagan would be able to serve all Americans as a responsible, impartial jurist, or whether she would bring her ideological agenda to the bench and attempt to get around the Constitution or the laws of the United States to effectuate what she thinks might be a better policy. That's the question I think that's legitimate to ask, as well as to ask in a serious way, what were you thinking when you punished our men and women in uniform because you didn't like what Congress and your president, President Clinton, did with regard to their policies on gays in the military? So it's not a small matter. I believe this decision was clearly wrong. I believe it was not lawful. I believe it was not good policy. And we'll need to talk about that as we go forward and to hear a sincere explanation from the nominee. I just say this to say, Mr. President, that this is not something that we can't learn from. It's not necessarily the decisive matter in this person's nomination. But I would say that it's not correct to say it is an insignificant matter. It is a significant matter, a very significant matter. And it is a matter of significance such that whoever comments about it, whether it's the Vice President of the United States even, they should be accurate. They should not be inaccurate, as has happened repeatedly from my observation in the media, as well as from my good friend, our former colleague, Senator Biden, who also served on the Judiciary Committee. So I think it's time we get these facts straight.